A small estate affidavit is a form that can be used to expedite the process of collecting assets from an estate that's considered small. Every estate defines small differently. In Iowa, a small estate is worth less than $50,000 and does not include real estate. In this video, we'll talk about how a small estate affidavit works, what Iowa law says about small estates, how to use an affidavit in Iowa, and more. Make sure that you watch to the end of this video so you can access a fillable small estate affidavit that works in Iowa. And make sure you subscribe to our channel for more videos about navigating all of life's complicated legal matters. First, let's talk a little more about what a small estate affidavit is. If your loved one didn't leave behind a large, complicated estate, then you can access his or her assets pretty easily and quickly. Using a small estate affidavit to collect anything your loved one owned allows you to avoid going through probate, which can be a long, expensive process that feels like it's never going to end. Every state has laws that guide the process of filing a small estate affidavit. In Iowa, if the deceased left a will and you're a beneficiary, you can file an affidavit. If there was no will, the affidavit can be used by an immediate family member chosen based on the state's succession rules. In Iowa, you have to wait 40 days after your loved one dies before you can file an affidavit. This gives you time to grieve and do some groundwork. You'll need to pick up a death certificate from a health office in your county. On our website, you can find a link to a locator that helps you find an office near you. You'll also need a copy of an obituary listing the family members who survived. You'll need a copy of a will if there was one, and trust documents if there was a trust. After you've gathered everything you'll need, you'll have to make an itemized list of all properties belonging to the estate and their individual values. You can then download the affidavit using the link below. The affidavit for information about all beneficiaries, including their relationship to the deceased and their contact information. Bear in mind that if there is neither a will or a trust, the beneficiaries will have to be able to prove their relationship to the deceased, either by way of obituary or the death certificate. You'll also have to include a social security number of the deceased. You'll then sign the affidavit in the presence of a notary public. After you've taken all of these steps, you can present the affidavit to third parties in possession of property belonging to the estate, such as banks or companies. The property can be distributed at this point, and you don't even have to file the document with the court. At eForms, we have the world's largest database of fillable legal forms, so if you need guidance through how to administer larger estates, we can help with that too, and with any other complicated legal matter that you'll deal with in life.